Morning, everyone. We're just waiting for everyone to be put through. Take a few seconds. Just a few more coming through now. Couple more. Okay. Just a few, just as I say that, just a few more coming through. Trickle, trickle. So just whilst we wait, obviously a bit of housekeeping as we always do on these Q&As. If you have a question, could you type question in capitals in the chat box, and then we will pick them as we go along. I'll ask Wayne to pick question, and then we'll have the question. Try not to type the question into the chat box itself. Just type the word question in capitals. Okay. So we are joined today on the Q&A by Chris Walker, who's the head of ATG Health and Safety. As you may know, we as a firm, Napton's acquired ATG Health and Safety in May of last year, and I suppose it's been timely in the sense that with this current situation, we, I suppose, HR professionals as employment lawyers, we're kind of working with the health and safety team now to help clients. So it's been really useful for us. And I just thought it was worth having Chris on today because he's dealing with organisations now who are clearly dealing with the prospect of having to make arrangements for the return of the workforce now, kind of going forward, which looks like it's going to be in the next few weeks at least for some organisations. So what I would like to do initially is probably just hand to Chris, just to do a few minutes on what he's seeing and what his thoughts are on arrangements that businesses are looking at, and how we may look at things as organisations to protect our staff and kind of get them back in. So I'm just going to hand over to Chris for a couple of minutes, and then if you've got any questions, as I say, put them in the chat box, and we can pick those up afterwards. So Chris, over to you.
Well, thanks, Chris. Morning all. Thanks for the invite to the Q&A this morning. As Chris says, yeah, I'm head of health and safety at ATG, part of Napton's group, and as Chris says, we've been dealing with quite a lot of questions and queries and providing as much support as possible to clients throughout the coronavirus situation. Really, we've sort of been tackling almost like sort of three phases or three groups of clients in various situations. So right at the very beginning of the outbreak, we were helping clients adjust and adapt to home working, making sure that we've got tools, assistance and guides for clients to ensure that they're keeping people safe throughout home working, but also making sure that they're meeting their statutory obligations and responsibilities to protect the health and safety of those staff and have the right documentation, risk assessments where relevant, etc. in place. While we were doing that with our clients, there were also obviously a broad group of clients who were operating either as usual, doing what they normally do, or doing something slightly different, using their existing workplaces where home working for specific activities wasn't necessarily possible. And throughout that time, we've been supporting them and making sure that they've got the necessary guidance to update risk assessments while carrying out their activities, while implementing government guidance on things like social distancing, etc. And really the phase that we're in now, and a number of our clients are in, and many of you will be facing this, is starting to think about reoccupation of the normal workplaces and what the rest of the year might look like from a managing our organisations and managing our employees' health and safety. So we're very much assisting with development of risk assessments and highlighting the key areas that organisations need to focus on within their workplaces, and they sort of broadly fit into three areas. there's the prevention of the spread of the virus within the workplace, and how you would go about implementing any relevant government guidance, be that on social distancing or otherwise, as we learn more about the virus and how it spreads. What impact will that those modifications and changes to your workplace actually have on your normal operations and the safety of how you go about doing things on a day-to-day basis? How will implementing measures to prevent the spread of the virus increase hazards and risks in other areas of the business? Potentially reducing simple things like reducing first aid cover and altering emergency plans, etc. If you've got reduced occupancy. And then really finally is preparing your actual workplace, the building itself, for reoccupation. There's a lot of things that might not have happened in your workplace over the past few weeks that would normally occur. Things like tests, inspections, maintenance of various assets within the building, maintenance and test of water systems, just as an example, that might not have been managed effectively over the past few weeks. And you might need to give some consideration to as or before you reoccupy your premises. So that's sort of just to give you a flavour of the risk assessment approach that we're helping our clients sort of work through at the moment. We've got a couple of webinars coming up specifically on those aspects on the 14th and the 21st of May, hosted by a couple of consultants, health and safety consultants from the team, who will be guiding you through a little bit more detail on the risk assessment approach, how to use risk assessment templates to come up with a suitable and sufficient assessment of the risks that your employees will face and the types of control measures that you might need. I'll hand back over to Chris because he said 2 minutes, and I'll keep going on for 10 otherwise. But I'll hand back over. Thanks.
Yeah, thanks, Chris. That's really helpful, and I suppose we'll kind of see how things develop as we go along. Wayne, and do we have any questions on the chat room yet?
None on the chat, but we did have one before from Rebecca Dixon, so I'll unmute Rebecca.
Okay, that's great.
Hi, can you hear me?
Hi, Rebecca. Yeah, hi.
My question is, I work for an HR consultancy, and quite a few of our clients are starting to talk about the prospect of redundancies. Now, I'm just a little bit unclear as to how that fits with the job retention scheme, because my understanding is that the job retention scheme is intended to avoid the need for redundancies. So I guess it could be considered a reasonable measure that needs to be considered to mitigate that. But having said that, with the there's already been one extension to the end of June, and it's likely to go to further extensions, I understand. To what extent is the employer expected to sort of hold on and wait for the scheme to end? And if they aren't expected to do that, under what circumstances could they refuse?
Yeah, I mean, I think the first thing is I don't think the employer is expected to wait for the end of the scheme per se. I think you're right. It could be argued in front of a tribunal, should it get there, that furlough should have been an option as opposed to simply going to a redundancy or to the end of redundancy exercise. But I think the thought process of the employer needs to be, why am I looking to make this redundancy? Is furloughing somebody actually going to impact on that decision-making process? And I think a lot of employers are concerned and worried that they shouldn't follow a redundancy exercise because furlough is an option, but it's only a short-term option, and that's the point. So if the decision to make someone redundant or go through the redundancy exercise for organisational reasons or economic reasons is there and is not going to go away, and it's clear to the organisation that it isn't going to go away, then the employer is at liberty to make those redundancies, and as you say, we'll have to make them sooner rather than later, in terms of the furlough scheme not being here forever. So, so I think kind of going back to March or to 20th of March and the weeks after that, it was always bounded around, well, would not furloughing somebody make redundancy unfair? I suppose there was potentially more argument then for the employee to say, well, this is very early stages, prove to me why you can't wait and put me on furlough and save costs. But I think now, some way down the line, if the furlough scheme is extended, then it's likely to be on a reduced sum It's highly unlikely to be 8 till. It's going to be in different sectors or specific sectors. So I think now an employer would be, I think a tribunal will take a fairly sensible view of this and say, you know, we're coming into the middle of May. If an organisation can demonstrate they have a fair reason for redundancy, then it strikes me as tribunals going to say, well, yeah, you've obviously considered furlough because the person's been on furlough, or you've demonstrated that you've considered it, but that isn't going to make a dismissal unfair at this point in time. So I think it's more thinking now about, is furlough effectively going to make any difference? And if it isn't going to make any difference, then the employee just gets on with the redundancy exercise. And of course, we're getting into the situation next week where collective consultation will need to begin for organisations who've got large workforces, because the furlough will effectively run out by the time they've got that consultation done. So, you know, there's going to be a period of consultation anyway around these things, I guess. But I take the view now. I think certainly as a team, we take a view that the time has come now. We just say it has to be done. It has to be done. Okay. So there's no obligation to see out the end of the drug
No,
absolutely not. Absolutely not. No.
Okay, lovely. Thank you.
Okay, thank you. Wayne, do we have any more at this point?
We do. We've got Lynn Metcalf.
Thanks. So we have got to the point where we believe that we are going to have to make redundancies, and we are going to be consulting during the furlough period. My question is, can furlough pay be used as the notice period pay?
Can you claim back the 80% of your notice
Yeah.
pay? Yeah. Yes.
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 Right.
Straightforward.
Well, thank you.
Okay, no worries. Any other questions at this stage, Wayne?
We've currently not got any questions in the chat. But I know you did have some that you might want to go to.
Yeah, so perhaps if people want to kind of have to think about any questions they've got and kind of fire them through. I guess I put in the preamble to some of the information about this Q&A session. I think we've gone through this kind of furloughing period now, and I think people are fairly comfortable with that. And we're going to go into this next phase probably of the return to work, and there probably are quite a few questions around that. And I guess I've been dealing with a few over the last probably week or 10 days, and I guess the recurring question appears to be, if somebody refuses to attend work, can we, because of coronavirus, can we terminate their employment or kind of refuse to pay them or do something to try and get them into work? And it's quite a complicated question, and I'll come on to some of the strands of it. But I suppose in principle, if somebody refuses to attend work, the answer is you can potentially look to dismiss them. But what we need to take into account is the protection and the circumstances, the protection that employees got and the circumstances around why they're coming in, or why they're refusing to come into work. So I think what I want to just show you up front, really, in terms of this point, is our favourite piece of legislation, the Employment Rights Act. And if I can just share my screen on this. Yep, there we go. So so if we look at the Employment Rights Act and we look at section 44, which you can see here. So section 44D and E are the relevant paragraphs. So this is all around employees who feel that there is a serious imminent threat to their health and safety. So 44D, the circumstances of danger which the employee reasonably believed to be serious and imminent, and which he could not reasonably have been expected to avert. He left or proposed to leave, or while the danger persisted, refused to return to his place of work or any dangerous part of his place of work, or in circumstances of danger which the employee reasonably believes to be serious and imminent, he took appropriate steps to protect himself or other persons from the danger. So in a nutshell, what those paragraphs are saying is somebody reasonably believes that there is a serious and imminent threat to their health and safety, and they effectively vacate the workplace as a result of that, or refuse to come into the workplace, then they have protection from suffering any detriment, which could be pay or any dismissal, and that right applies to employees who have been employed from day one. So that this is not an unfair dismissal right which has to accrue over 2 years, the continuous service. It's a day one right. So that clause is probably going to be the section, or that section is going to be the piece of legislation which employers need to be aware of, and employees will probably seek to use should this progress, these issues progress further down the line to tribunals. And I guess the main word within there for employers is probably reasonably believed. So does an employee reasonably believe there's an imminent threat to their health and well-being? And that then falls into some of the points Chris Walker was making at the start. What does an employer have to do in order to tick that box that they've done everything that is reasonable, so that employee can return to work? And the starting point for reasonableness in this context has to be the government guidance, you would have thought. So the government guidance that we currently have, and probably additional government guidance that we're going to get. But other, I guess, common sense measures that an employer may think about taking to prevent the spread of the virus. And of course, some of these things will be specific, dependent upon the reason for the individual not wanting to come back into work. But those are the areas that are going to be of concern, really. What is required for there to be a reasonable belief of the individual that there is a serious and imminent threat? I think it's clear that, as we've seen back in the original guidance from the government, that coronavirus is likely to be deemed a serious and imminent threat, because the government and Public Health England defined it as such in their guidance, that it's a serious and imminent threat to public health. So the employees are probably going to be able to tick that box. So it's almost looking at what employers can do to prevent that, and to ensure that there is no reasonable belief that serious imminent threat is going to affect that individual. Chris, is there anything you want to mention on that in terms of actions that employers might want to look at?
I think you outlined the key point really there, that the employer first off is responsible for assessing all of the workplace risks and introducing measures that so far as reasonably practicable protect the employee. One of the things that we've been discussing when looking at the risk assessment and the implementation of control measures that go alongside, or go at least as far as, the government guidance on prevention of the spread of the virus, is ensuring that we maintain the consultation with employees about those measures throughout the process, just so we can ensure that they are comfortable with the measures, and have mechanisms to escalate concerns in areas that we've not necessarily identified ourselves as presenting a risk, so that we can put in place satisfactory control measures and avoid the situations arising where employees don't feel safe to return to work.
Yeah, and I think certainly from an employment law point of view, working with what kind of health and safety, Johnny, I think what we would want to see, and certainly employment tribunals would want to see on this Section 44 point, is certainly discussion, consultation with individuals to try and ascertain what their concerns are, and try to demonstrate to the individual that they've actually taken those on board, and then put any measures in place which may mean that their fears are alleviated to some extent. So I think that consultation point is pretty important in terms of kind of working with individuals. I guess from a linked point as well, are the extremely vulnerable categories, so the extremely clinical vulnerable category of people, I guess first up, are they going to be disabled for the purposes of the Equality Act? I think it probably makes sense to have a quick look at that from the original guidance that we got. So I can share my screen on here. So I think you've all probably seen this many times now, pinned to the wall of your office. Who is clinically extremely vulnerable? So this is the list this is the government guidance that employees have been receiving letters from the NHS, and in some cases GPs, as we've seen as time is moving on. So this list of individuals going to be disabled for the purposes of the Equality Act? And the answer is, well, yes, it's highly likely that the majority of these people will be deemed to be disabled. Obviously, cancer is deemed as a disability under the Equality Act. So it's likely that we're going to have these issues that we need to take into account in terms of assessing our obligations under the Equality Act when we are looking to bring people back into work. So what sort of reasonable adjustments are we likely to have to make, or what reasonable adjustments do we think we have to make if we're bringing employees back into the workplace? And obviously an obvious one is a phased return, maybe reduced hours, that sort of thing, to get people back into the place of work if they feel that they can come into work. So it's just another layer probably of complexity that we're maybe going to have to look at in the next few weeks and months as these things go forwards with that extremely vulnerable category. Wayne, before I carry on, do I have any other questions?
Not as yet, no.
Okay. So that's one of the...
Yeah, there is. Sorry, Rebecca Jones.
Oh, sorry.
Just popped in. 1 second. Okay.
Hi, Rebecca.
Yeah, sorry, I was having trouble with my keyboard.
It's all right.
Sorry.
Yes.
I'm sorry, going back to redundancies, and sorry to be boring to drag that back up again.
All right.
Our sister company actually only has one member of staff, and unfortunately, due to the nature of the business they're in, they're actually now running at a downturn of about 50% on last year. And it's looking more and more likely that we're not going to be able to maintain having the one member of staff. I mean, work has literally dried up at a rate of knots at the moment, and it's probably going to have to go back to a single person operation. With the fact it is just one person, how can we not drag it on? Because obviously we've got the process to follow and everything, but with the consultation and everything, but it's a case, obviously, it is just one person. There isn't other roles to look into the business and everything. It's a case of trying to make it, if it is going to have to be that outcome, as easy for the member of staff as possible.
Yeah, I think if it's just a unique position where we get situations where it's a unique role, it's just one role and there's no pooling or anything like that selection, then you can pretty much just deal with it reasonably swiftly. So whenever you feel that it's the appropriate time to do it, then you just put the individual at risk. Have the consultation meetings, which principally have to box off 2 areas. Are there any ways to avoid the redundancy, and is there any suitable alternative employment within the organisation? Once you've boxed those 2 issues off, then there's not much else to talk about, and you can then just give notice of termination at that point. So you would expect some, I mean, we tend to say that if it's one person, it's reasonably straightforward. It sounds like yours is reasonably straightforward. You would probably be able to get that done within a couple of weeks, easily. Yeah.
That's great. That's fine. We kind of brought the process around that if it does have to go that way. I mean, you never know. Next week there might be a bump and we might be okay. But I say, it's just to be prepared, unfortunately. Yeah,
I think this is it. I think you're right. I think the main challenge that a lot of employers seem to have at the moment is timing of redundancies, especially when it's, you know, if it's one, it's not as difficult, but if it's more and it's a collective, then it becomes more. And that's, I suppose, what every employer is trying to assess, aren't they, from a cost point of view at the moment, when to I suppose, push the button, really. Yeah.
That's great. Thank you.
Stuff. Thanks, Rebecca.
There are
okay. So, sorry.
There are no more.
Okay, Wayne, thanks. I should have said we'll probably do 30 to 40 minutes on this Q&A session, unless we get more questions through. But so just moving back to this point then around the clinically vulnerable, the extremely vulnerable. What happens then if an employee or an employer wants a member of staff? Let's say that member of staff is a significantly important person within the business and they're extremely vulnerable, clinically extremely vulnerable. Can we compel that individual to return to work? And I suppose it's probably not surprising to conclude that it's going to be difficult to compel that person to return to work. If they're extremely vulnerable as defined as it stands, we would have to consider the health and safety issues which I mentioned before under the Employment Rights Act, and I suppose also the guidance given and by the government going forward as well. So if we look to compel someone to return to work, then we have that automatic health and safety dismissal point on the one hand, should it come to that, and then obviously the detriment point as well. And then on the other hand, we have the fact that the clinically vulnerable person, extremely clinically vulnerable person, as they're likely to have a disability, then they have protection, I suppose, in terms of the Equality Act. So any treatment which is less favourable would be unlawful. Or if we look to take action which is based on their disability or something arising from their disability. So you've probably come across Section 15 claims under the Equality Act, which is something which arises from a disability. So this would probably fall into that category, having to do something because of their disability. If we took any action, then that would probably put us at risk of those claims as well. So the best option is probably to look at reasonable adjustments, as I mentioned before, and to try and work with the individual to mitigate any concerns that they potentially have, and look at the risk assessments as well, demonstrate that you've carried out proper risk assessments, done everything you can reasonably to try and protect that person. But if not, then that person will likely have to remain off. And as it stands, obviously, for that extremely vulnerable category, we have statutory sick pay provisions in place at this moment in time. That there may be further discussions with the individual as an organisation that you may want to have about pay going forwards on that as well. So that deals with the extremely vulnerable. I did want to just touch on the definition of a vulnerable employee as well, because I think this has been, it's probably been lost to a degree over the last few weeks, but I want to deal with it now because it's going to be relevant when people are returning to work. And so the vulnerable category was defined within the Act. I can just show you it rather than me trying to remember it. So I'm sure you've all read the Health Protection Coronavirus Restrictions England Regulation 2020, again pinned up on the office wall, obviously. This was obviously the Act that was, and the regulations that were introduced in terms of what people should and shouldn't be doing, and the fixed penalties and all that sort of thing that we got in, and the social distancing and that sort of thing. So the relevant part of this is Regulation 1C, and this refers to a vulnerable person. So if you see here, 1C, vulnerable person, any person over 70 or older, any person under 70 who has an underlying health condition, including but not limited to the conditions in Schedule 1, and any person who's pregnant. So you'll remember that this was the list, or the type of people that were referenced right back at the beginning of all this. The law has somewhat changed, or the guidance has somewhat changed on this, but we now have these regulations. So if we look at Schedule 1, we have a list of what are deemed to be vulnerable people, so vulnerable employees. This is a different list than the one we just looked at before. You might say, you may say this is people with less serious underlying medical health issues, albeit still serious. And I guess the question for these individuals is going to be, bearing in mind they're not specifically now referred to in the guidance, it's going to be, are these people going to be excused, I guess, in terms of as extremely vulnerable people may be, in not returning to work? And can we actually ask vulnerable people in this list to return to work? And I guess this is where the difficulty is going to arise, because it's going to be a question of degree on the individual's health. It's probably not going to be too much of an issue for, we go back to 1C again, people who are pregnant, and maybe even people over 70. Maybe there would be more ability to say to the employee, you just need to get yourself into work. We've pulled all these things in place. But for these other people with underlying health conditions, there may be more of an issue. So again, with those people, there's probably more of there's probably more flexibility, but we still need to go through these processes in order to try and demonstrate to the individual that we've done all the risk assessments possible, and identify specifically with these individuals whether or not they suffer from a disability, because the disability point under the Equality Act with these persons is probably going to be more of a grey area than it is with the extremely vulnerable category as well. So we would just need to probably, and it might be that we have to look at, as we were normally doing ill health dismissals, have to look at, kind of referring individuals onto occupational health in order to really understand the reason for the ill health. I was asked yesterday on our Facebook community page also about individuals who are are not shielding, but are currently living with somebody who is shielding and therefore cannot attend work. What happens if an employee wants to shield at home because they're living with a vulnerable or extremely clinically vulnerable person? And can we permit that to continue? Can we ask them to come into work? And I suppose the answer, I go back probably to Section 44 of the Employment Rights Act, which you recall when I looked at that before, refers to other people. So there's going to be health issues or injury caused to another person. Somebody may become ill, then that person has that protection as well. So it doesn't need to be necessarily in respect of the person themselves, that they don't need to be in any sort of imminent danger. It might be that somebody else is that they're with. So that person will be able to rely upon Section 44 of the Employment Rights Act as well. And while they may not be able to claim a disability, they have that protection. So again, with those individuals, probably the discussion's possibly easier, but it comes again back to demonstrating that it's unreasonable for them to believe, or it's not reasonable for them to believe, that they or the person they are shielding is in imminent danger. And there's good examples of employers taking action on this, especially in the care sector and the education sector, where schools have been obviously in and to a degree, and in the care sector where individuals have been working in care homes, and they have implemented certain strategies and measures which to attempt to minimise or attempt to mitigate the potential for any danger to people that they are living with and are shielding. So that's something to take into account, because we have seen quite a bit of that, where sons and daughters living with their elderly parents. Okay, so Wayne, do we have any questions?
We do. There's a question from Elizabeth Cox.
Elizabeth?
No, maybe not.
Elizabeth, are you there? No. Okay, all right. Okay, well, finally, I mean, if there are no more questions, then I guess I did say as well that I kind of briefly deal with I guess the process in terms of returning to work. Oh, sorry, I think we've got a question there, Wayne.
We do. Shauna Taylor. 1 second. Yeah, Shauna.
Hi. What if the scenario is an employee does return to work and they do contract coronavirus, and is there an employer liability and director liability for that?
Chris, do you want to take this one? Yeah, sure. Thanks, Shona. From a health and safety perspective, you're going to be required to demonstrate that you have done everything you reasonably practicably can to prevent that occurring. Now, within your workplace setting, and obviously the likelihood of exposure within workplace settings is going to vary. If we were talking, say, about a health or care setting in particular, then obviously the measures that you would need to have in place would be significantly greater than those for the ordinary workplace outside of that sector. I think what you need to sort of think about from a health and safety executive enforcement perspective is obviously the RIDDOR requirements, so the reporting of diseases and dangerous occurrences, injurious diseases, dangerous occurrences regulations, only require you to report instances where there is a high likelihood that the exposure occurred within the workplace, and it was because of a workplace exposure or a potential workplace exposure to the actual virus. Now, in an ordinary workplace situation, it'd be very difficult to nail down, yes, absolutely, that exposure came from the activity in the workplace, which subsequently resulted in the condition. So I think if you've done everything that you reasonably practicably can to, in the first instance, implement whatever the government guidance is, including social distancing and other measures at the time, and have acted upon any specific concerns raised by employees, and acted according to your risk assessment, then you should be able to rest assured that you're unlikely to face any action should an employee end up suffering with a condition. In the event that you've entirely ignored all of the government guidance, failed to carry out a risk assessment and implement control measures, should that individual get coronavirus, whether it's from your workplace or not, there's a likelihood that they'd be able to argue, certainly from a civil claims perspective, to seek compensation in that event. So having a robust risk assessment, following the government guideline as a minimum, and ensuring that you implement necessary control measures will put you in the best position to defend against any such instance. Does that answer your question?
Yeah, that's great, thanks.
Lovely.
Thanks, Shona. Okie doke. Yeah, okay. There's been a few. I think I've said on Facebook and maybe on LinkedIn as well that I'd answered. There's a few questions around the process in terms of the end of furlough. It has been raised a couple of times. It's reasonably straightforward with the end of furlough. I mean, I'm sure the majority of organisations will have a furlough agreement in there in which the reasons for the return to work will be specified, if not the process. But if it's in the agreement, which I'm sure the majority of people have, then you just apply the agreement. If it isn't, then it's just reasonable notice. So you would just give notice to the individual that you intend for that person to return from furlough on a given date, so whether that be the following Monday or whatever it may be. Keeping in mind that obviously the individuals need that and that minimum 3-week period in which to claim back, in which an employer can claim back the grant from the government. Once an employee is back into work, obviously the employee's pay will return to its normal contractual rate, unless you've got some previous agreement with the employee. I know that some employers had inserted terms into the furlough agreement, which referred to layoff and short-time working. So it may be that you want to rely upon those at that point, should furlough come to an end. And obviously some employers will be looking to vary terms and conditions as well. So I'm sure a lot of employers, as we mentioned before, are now looking at the options should furlough end. And one of those options is going to be variation to terms and conditions of employment. So that's a reduction in salary, and whether or not that's accompanied with a reduction in hours is for agreement. And clearly that can only be done by consent with the individual up front, or by going through a period of consultation with the employee. And that would then ultimately, if the employee simply then refuses to agree to the variation, then you would be into dismissal and re-engagement. So you would have to consult, get to the end of that process, and then dismiss and offer to re-engage on the new terms conditions at that point. So that's a whole different area that we could discuss at some point in the future, I'm sure. Okay, so I think those were the only things that I wanted to deal with today. does anyone, if anyone has no more questions, it's 20 to 12, so that's good. Just check one more time. Wayne, any more questions?
Nothing in at the minute, no.
Okay, all right. Well, let's leave it there then. We have some other events coming up, as Chris mentioned some before. We have some specific HR3 panel discussions that we're doing in the next couple of weeks. And we'll probably look to another Q&A probably in the next 14 days as well. We are running a reintegration hub, which you may have seen, you may have received emails about, which is a 30-minute free consultation with our HR, health and safety and employment lawyers about some of the issues we've talked about today. It's there simply to give people a forum to ask questions and to get some advice from those three areas areas of services that we provide. So we will send a link out in the follow-up to this as well. And if anyone does require that, then obviously just pop us an email down and we'll sort out a consultation. But other than that, thank you very much and have a good day. Thank you.